Hello, I'm Angela Prinzel, and I want to talk to you about a very discrete issue again today. And this has to deal with child support in shared parenting arrangements. So, most people believe that if they have a shared parenting arrangement, um, and in that context, I mean, the children are spending equal amounts of time in both homes, that they don't need to pay child support. Well, I hope, in my other videos and podcasts and things that we've been able to dispel that. It doesn't matter that the child spending equal amounts of time in both homes, child support may still be payable. However, a lot of people, or in a lot of cases, the child support that's paid is not the full amount, and it's usually a set off. And what does a set off mean? It just means that I'll just call it mom and dad, and the child spending equal amounts of times in both homes. So if mom has a lower income, then maybe she has to pay, you know, $500 a month in child support to dad, who maybe has a higher income and has to pay $1,000 child support. In those cases, I'm speaking of the respective full tables amount. So for one person, the full child support amount is $1,000. For the other person, it's 500. The set off in this simple example is dad is paying $500 more to mom. And it seems very simple and straightforward. It's a concept that a lot of people are understanding. But what I want to propose to you today is be very mindful before you enter into an agreement where you just use the simple set of amount. While it might be mathematically easier and straightforward to just say, instead of John pays Jane $1,000 in child support and Jane pays John $500. We'll just say John pays $500, call it a day. It's easy, straightforward. However, you want to think about, the child tax credits and things like what are the benefits that you're trying to get from the government, so to speak, because the way your child support provision is worded might actually affect your ability to get these tax benefits or credits. And so what I'm proposing to do is, and this is what we do in our agreements, we would actually specify that each party pays the amount of child support that they ordinarily would have to based on the child support guidelines. And so that's the reason why we do that, because I have had people ask us, well, can we just pay the set off amount? No, you can't. And so because if you do that, then one party would not get their entitlement, and it creates a whole mess. And so that's why you have to do it that way. But beyond just the words in the agreement, you actually need to pay each other these support amounts. You need some kind of evidentiary basis, because if there's ever an audit done on you or CRA has any questions, then they want to see, the support checks that were made or the indirect aid transfers that were made. So be very mindful of that. I know we have our separation agreement templates that people purchase and kind of modify and use for their own purposes. And so I just want to be very clear that people need to be mindful. We do have these provisions in our templates, and that's the reason why. So when you're drafting the agreements, don't just have it plain set of amount. Make sure you're clear on who pays what. Interestingly, I actually had a lawyer take issue with an order that I did, and the lawyer said, well, it should just be the set of amount. And I'm like, no, that's not what we're doing. The reason why I'm doing this is as a result of the CRA requirement, and it's actually out of a 2016 Tax Court of Canada decision. So I know I have talked about this before, but it's a recurring thing that I am question that I keep getting, where people just wonder, why wouldn't it be so simple? And in a recent matter that I have where this has come up, the party raised the question of, or my client raised the question that I don't know if the other side is going to pay me. So you're saying, well, I need to pay him $1,000 and she needs to pay me whatever amount. What if I don't get my payment from her and I've given it, I've already paid my support amount. So I'm kind of in the hole here, so to speak, right? Because they have the full amount and now I don't get that set off amount, and we have a shared parenting arrangement. I obviously need these funds to offset the child expense, the child's living costs while in my home. Very valid point. And what we did to resolve this issue was I said, well, she gets to pay first on, say, the first of the month, and then I made my clients support amount payable on the second of the month. So in which case, if the money, and it's in this case, it was e-transfer, so it should come in immediately. If you don't receive the payment on the first, then there's a conversation to be had before you make your payments on the second. But that's that's one way to deal with the issue. I'm sure there's lots of other more creative ways that this can be dealt with, or I'm not going to go into a lot of options because there are various ways to deal with that, but I recognize that that's a fear that people may have in that situation. So the only point I have to make for today is be mindful to not only include the set-off amount when drafting your child support clauses and shared parenting arrangements. Just be mindful and make sure that you include, the fact that each person is paying the full table amount of child support. Otherwise, you could affect your chances of being able to get tax credits and benefits and things like that you may otherwise be eligible for. So all the best, and I will talk to you next time on our next video. Take care.